Ms. Nicole CG. And I am Greg Tanzi, the vice chairman who will be chairing tonight's meeting. Just going to read the advertisement into it. So at being 7:30 p.m., remotely conducted public hearing will be held by the Rockland Zoning Board of Appeals on Tuesday, January 3rd, 2023 at 7:30 p.m. on the application submitted by Andrew Shahanan, manager BNS LLC, care of attorney James S. Timmons, 55 Willard Street, Quincy, Massachusetts, for a use variance pursuant to section 415-21.2E3C, Downtown Rockland Revitalization Overlay District, and section 415-89.1, zoning variances. The applicant is proposing, if approved, to legalize an existing first floor rear residential unit. The property is located in the B1 Business 1 zoning district, section 415-13 of the bylaw, and is further identified as lot 068 map 45 on the Rockland Assessors map. The owner of the property is BNS LLC. Attention, Craig Borganasi, 1146 Oliver Ave, number C, San Diego, California, 92109. So with that, I would like to invite the applicant to present.
Greg,
Yes.
before you do, I just want to I believe we're supposed to, are we still doing an announcement that all the members are engaging remotely?
Yeah, what I had said that this is being video recorded. We're all engaging remotely, and it's going to be audio and video recorded. So,
who's going to vote on this, Greg?
Voting on this will be Mr. Haynes, Mr. Galley, Mr. Galley Jr. I'm sorry. Mr. Baker Jr., and myself. With that, Mr. Timmons, you may proceed.
All right, thank you. Good evening, Mr. Chairman and members of the board. I've been introduced, so I won't repeat my identity. I'm attorney Jim Timmons from Quincy. I represent BNS LLC, which is a title holding entity. There are two individuals involved, Andrew Shanahan, who is with me this evening, and Craig Borghesani. They're gentlemen who own real estate in the region. They own other properties in Rockland. I prepared a narrative that I submitted with my application, and I may just hit on the highlights of that. I think that due to the efforts of your chair, who's not present tonight, and Ms. Shuttleworth, I trust you're going to find my application to be complete because it was, I've been talking with Mr. Rubel and Inspectional Services since late in the summer about this application. And Ms. Shuttleworth was very helpful to me. I'd just like to note that fact. The application submitted by me, the applicant claims to have pre-existing rights in the building. There's a rear unit on the first floor, which is being used for residential purposes. However, the property is in the recently created Downtown Rockland Revitalization Overlay District. So for that reason, it called into question the legality of the use of the rear unit. Mr. Rubel and I have had several conversations, and he felt it was appropriate that we seek the relief requested this evening, a variance, in order to allow for the residential use in the rear of the building in this district. I have cited in my little memo that I submitted ahead of time that the variance here is not going to cause any detriment to the public good. The purpose of the overlay district, as I'm sure you know better than I, is to create business uses available to the public on the first floor along the main vias in downtown Rockland, but also to allow for the provision of housing in the downtown area. This building is perfectly suited to do that, with the one exception that the rear unit, which is the subject of this application, it's entirely facing to the rear of the building. It's got no front-facing space at all. For that reason, when the current owners sought to engage with commercial users, they weren't able to get any takers. So the property has been used as a residential unit, we believe, since at least 1993, based on history available to us. And the fact of the matter is that while BNS has owned the property, they've very readily had tenants. There's been no issue with getting users for the unit. There's a demand, as you folks would be aware, for housing in the downtown. These are 5 one-bedroom units, and it's been operated by Mr. Shanahan and Mr. Borghesani with great success relative to the tenants. The residential units seem to work out fine. So I would respectfully suggest that where the town of Rockland provides for the board, it gives you authority to grant a use variance. We're asking that you grant this particular request, that the rear unit be used for residential purposes, notwithstanding the fact it's on the first floor. So having previously presented this in my application, I'm happy to stop at this point and answer any questions the board might have.
Mr. Haynes, do you have any questions?
The only thing I was wondering, I didn't see anywhere in the, I looked at the assessor's card and permits. I was just wondering if permits had been put, like, had this unit been legally created as a residential unit at some point? Like, do we have a permit history of the conversion of this unit at some point in the past where it was done with actual, like, town acknowledgement and approvals?
Understood. I have a document in front of me that's not part of the record. I could scan it and upload it to the Zoom screen if you cared to follow up with me, but I'll represent to you that I have a permit that Mr. Rubel was kind enough to allow me to review the building department file, and this application for building permit was taken out, and it specifically says the work to be done is to remodel the rear apartment first floor. However, and this is somewhat inexplicable, and it's one of the reasons why I didn't submit it, it's completely undated. There's an area at the top to date it. It's not dated there. It's all signed off at the bottom, and it's not dated there. There was an estimated cost of $5,000, and one of the tenants in the building at the time is identified as Anthony's Tailor Shop. So I'm not aware of Rockland historical use of this building, but it was owned by a DNR trust, Anthony's Tailor Shop. And that's what I have as far as a legalization of the unit. I might defer a bit to Mr. Rubel, who's discussed this issue with me, because one of the things that I talked about with him was the absence of work that related to weight-bearing walls or anything like that. But he's been through the unit once, and if he cares to speak to it, he might be able to provide amplification on what I've just said.
Okay.
May I just add, I beg your pardon, I also have a listing. I make reference in the little narrative that I prepared to the fact that we believe that this unit's existed since November of 1993. We have an MLS listing that was prepared and published and dated November 11th, 1993. And that document indicates that it's a mixed use with the 5 residential units.
I think that's my only question. I think something I'd like to determine is just whether it was at some point a legal sort of pre-exist, like it may pre-exist the zoning changes. I was just wondering if it legally pre-existed. You know, if somebody illegally converted the apartment from commercial to residential use, I'd like to know, sort of get a sense of you know, whether it was done, whether it was converted with the permission of the town at the time and with permits or not. So I'll table the question for now until Tom has a chance to talk to us.
May I just, in furtherance, there are appropriate means of there are 2 means of access and egress to the unit, and all the heights check out as far as state building code issues. And as I said, I know that the unit's been inspected in the recent past. It's not a direct answer to your question. It's just some factors that contribute to, you know, allay the concerns that there may be issues with the unit. Thank you.
Thank you. That's all I have for now.
Mr. Baker, do you have any questions, the applicant?
How many parking spaces are required by zoning for this building?
There are 5 striped spaces in the rear. I provided pictures showing the spaces, and then also on our site plan, you can see the spaces.
But by the zoning bylaws, how many spaces are supposed to be here?
Well, my answer to that question would be, because this is all pre-existing, that the number of spaces that are there are compliant due to non-conforming rights. But I believe, I'll say that the current zoning requires, I believe it's 1.5 spaces per unit. It could be as high as 2. Mr. Rubel could tell you, but it's certainly more than 5.
Hey, we got a letter from the abutter that shares the driveway. We got a letter today. He had concerns about the parking spaces because there's no on-street parking during the winter, and during snow removal, you may lose those spaces.
Well, the current owner, Mr. Shanahan, Mr. Borghesani, they also own property just on the other side of Dunkin' Donuts, 143 to 159 Union.
We have a contingency plan that they.
So they've made all their, the unit owners aware that if there's an issue with snow, and I'm sure, as you know, that when it occurs, it's infrequent over the course of a year, that all the cars can move to that lot. It's an open air lot that's easily cleared, and there's always been space there. During the course of time that Mr. Shanahan's been managing the building, he's never had an issue with that, and there has been snow.
The owner next door stated that he would like to talk to your clients about the parking situation.
Who is the letter writer, please? I had checked in at about 3 o'clock and no one had submitted anything. Otherwise, I'd be prepared to answer this. And I personally.
Jeff, do you have a copy of that?
Pardon me? Oh,
That email?
I think you're muted.
You muted, Deb.
Yeah, sorry. Yeah, let me see if I can pull it up. It's on the, I don't know how to pull it up. It's on the website. I got it from, the building
Jim,
department.
Jim, what's your email address? I'll email it to you right now.
You have it?
I have it. I'll email it to you right now.
J Timmons, Timmins.
Yeah.
At CronenTimmons.com. You may have it, Bob, in your system already.
Okay.
J Timmons at CronenTimmons.com. Thank you.
Okay, it's on its way.
Thank you.
What side is it for? Can they hear us?
It looks like it's an old letter, Jim, that was resent to the board today at 5:48. Well, didn't come through. I could pull it up. It does. Mr. Tanzi, do you want me to pull the letter up so we could see it?
Yes, please, Mr. Galvin.
Just, I just got to make sure I have it up here. Okay, I'll share my screen now.
Okay, I'll go with that.
Are you able to see that now?
Yes, Metro Management. We spoke.
We spoke to them. We had their blessing.
It looks like the letter was a copy of a letter that was written a couple of years ago. And it looks like it was resent today.
I don't have my notes handy, but I went into that operation and spoke, but it was to a man,
Well, you spoke
a
to the
male,
son.
not a female.
You spoke
It
to
looks
the-
like it was written by a John O'Connor.
What's his name?
John O'Connor from 26 East Water Street.
Okay.
26.
Well-
We spoke to the son of the owner, and we also spoke to the secretary as well. At one point, I had a tenant by the name of Mary Brooks, decided
Well,
that,
let's not.
oh, okay, but anyways, decided to fire it up with them. That probably generated that letter. Since then, we've come to a lot of understanding that we're close together and to get along. And I'm kind of taken back from this letter. I'm kind of surprised at it.
It looks like if you see in the upper left-hand corner, it didn't come in until 5:48 tonight. So
Yeah, I can only say that, there's a perspective here, perhaps, I don't know, but I know that when we went and spoke to them prior to filing the application, I personally spoke it. I believe it may have been John O'Connor. You said a son. but-
Yeah,
All right, so that's good. I'll just
Okay.
finish this thought. So I understand this concern. I can only say there's on-street parking, and then BNS owns the lot that I identified earlier and has an agreement in place with their tenants to park there if there's snow issues. But we can certainly work with an abutter about, they say recently, that's July of 2021. I just don't know.
Yeah.
Yeah, I don't know what the deal is there.
Well, they sent it to us today too,
Understood.
for the
No,
channel.
understood.
it
Yeah.
looks like they're asking that any new tenants be advised of the agreement that they have with you all regarding access and parking.
that's in our leases.
And that's fine. Andrew just advised me it's in the leases, but there will, I think perhaps, because I do recall this discussion, but I thought it was with the abutter on the other side, that sometimes tenants will do things that run afoul of the two abutters. But yeah, I know Andrew's worked hard on those issues when they arise, and
Yeah, we
Well-
try to keep it open. We try to keep an open passage. That's our concern. And with good right too, because we share the driveway. We don't want to block anybody into it or create heartache when someone's coming home from a hard day at work. So we both came with the agreement that we'd keep that right away to the back of the building open. For
Mr.
both.
Chairman, I'm going to take that down now so you guys can,
thank you.
okay.
We lost Greg.
Steve Galley,
No, the questions have already been asked. Thank you.
Nicole Gomez. Do you have any questions?
No, I do not. Thank you.
So my only question is when was the last time the apartment was used as a residential, was occupied as a residential use? Is it occupied now as a residential use?
It has been continuously occupied as a residential use since BNS purchased the property.
30 years.
And it's an issue that we ended up dealing with Mr. Rubel on. He was upset. He wanted me to get this in front of the zoning board because he was uncomfortable with the fact that, we had this dispute ongoing about whether the owner enjoyed non-conforming rights or he needed a variance. So I know that since BNS closed on the property, which is October of 21, and prior to that date with the prior owner, that it had been used consistently as a residential use. I saw an appraisal that had been done at the time of the closing in October of 2021, which referenced that the prior owner was using it residentially. And then we have some anecdotal use that it was used residentially prior to that as well.
Okay. I'm sorry, Mr. Baker Jr., did you get a chance to ask a question?
I didn't, Mr. Chairman, but that's everything that I had been wondering about, at least from the applicant and council, has been answered. I may have some questions for Mr. Galvin and Mr. Rubel, but I'm fine for now. Thank you.
Okay, thank you. I apologize for skipping you.
Not at all, Mr. Chairman.
Mr. Galvin, do you have any questions or comments? I mean, my only question, Mr. Galvin, is what would constitute a legal use of that space for an
Well,
apartment?
if someone issued a building permit for that rear unit more than 10 years ago, and I know we don't have a date on that permit that Attorney Timmons found, but if Mr. Rubel could give us his belief as to when that issued, that may have some bearing on our ability to, order this to be removed if it existed. I've never been to the property. I don't know whether the board wants to see the property. I see Chief Duffy is here. So he may have some knowledge too. He's been around a long time and probably even inspected the building, or someone working for him has. I think it really kind of depends on what Mr. Rubel thinks about that permit that apparently issued for this building.
Okay, very good.
May I interject on that issue?
Yes,
I beg your pardon.
sure.
Were the relief to be granted tonight and you allowed for the use, then the plan was to have an application filed with Mr. Rubel, and he would inspect the property and then issue an occupancy permit as long as he found the property okay. He's, to my understanding, refused to this point because he regards it as an illegal use.
Okay. Mr. Duffy, do you have anything any comments that you wish to make?
Thank you, board. I appreciate you having me here. I will say that we had a substantial fire in this building about almost, I believe it was 3 years ago now, 2019, I think. That building stayed vacant for quite some time and unused while they waited repairs. Upon the completion of those repairs, that building was received a certificate of occupancy, I believe, issued by Mr. Rubel's office for business on the first floor only, and the residential on floors 2 and 3. It was also relayed to the previous owner by Deputy Chief Heaney and myself. I will say that if the board decides to take any decision tonight on this property and they And they grant any type of use for residential use in that first floor, adding a unit. I would request that the board stipulate that an automatic fire sprinkler be installed throughout that property. In accordance with NFPA 13. Thank you.
Thank you, Mr. Duffy.
Looks like the health agent is also present. She may have some thoughts on it.
Yes.
I have not been involved in this property, but there are certain requirements that CMR 410 that I do go by.
Ma'am, do you have any concerns or issues with this property being in violation with
Well, absolutely, I would have concerns if it doesn't meet the requirements for fit for human habitation.
Okay. Very good.
Just if I may, Mr. Chairman, to follow up on that remark, do you have any indication at this point that the unit or the building as a whole do not meet the requirements for human habitation?
I have not been at the property.
Okay. Thank you.
You're welcome.
Does this property have a dumpster?
Yeah, it has 4 one-yard containers there and 4 one-yard recycling containers as well, supplied by the town with weekly pickup.
Are they fenced in?
But they're not fenced in, they're in the back of the lot. They're in the back of the building, off street. But they're not fenced in.
Health agent, are they supposed to be fenced in?
They are. We haven't yet hit the ground running and went out looking for dumpsters, but that is happening come the spring, that all dumpsters, commercial and residential, have to have their dumpsters enclosed. We will work with people because I know that some of Andrew's property, you can't. The way they're set up, especially on Union Street, but this is Eastwater. And again, I haven't been to the property.
That's the first, I didn't even know of this, I didn't know this would be a bylaw, this new kind of a bylaw.
Don't worry. that's
Yeah.
fine.
So I don't have fence.
No question.
Okay.
Yeah.
It's a new regulation that was set this year. I believe it was in the spring of this year, and I can forward that to Andrew if he wants. And again, if the property has some questionable issues, we'll work with them to make it suitable.
We can address that.
Are there any other questions for the board or for town council?
We hear from Tom?
Yeah, here's Tom. Mr. Rubel,
Yeah,
do you have any comments that you would like to make regarding this application?
yes, thank you, Greg. Jim, on that application, on that permit, who was the building inspector then?
I can't read the writing. Hang on one sec. It looks like it's something junior. Maybe it's Chicolo or something.
I don't know, but
There's a middle
anyway,
initial J and then it says junior. Oh, no, that's the owner. Yeah, I don't see,
I had a building official name.
yeah, I don't see a building official's name. What I see is, I beg your pardon, that was the building owner. What I see is building permit number 2469 written on it. 2469 handwritten.
Yeah, I don't know. Well, I don't know how far you want to go back, Greg, but in the late 60s, early 70s, that was a 3-alley bowling room. And it has 4 pool tables in there called Bill Brown Pool Hall. How it got converted into an apartment when in the back without a permit, I do not know. When the place was being remodeled, I told the old owner when he remodeled it that apartment on the first floor is not allowed. And he agreed with me. But they had put somebody in there that had left when they found out that it was illegal. And for some reason, somebody else went into that apartment when Shanahan bought it. So I do not agree with this apartment being on the first floor because I knew what it was in the late 60s, early 70s. It was a pool hall and a bowling alley. How it got converted, it's a narrow building, but long. That's where the 3 alleys were. So how it got converted, I don't know. And it was substantially remodeled, and therefore I don't feel that that apartment should be there. But it's up to the board. And I agree with the chief.
Okay. If there's no other questions from the board at this point, is there anybody in the audience who would like to speak in favor of this application? Okay, hearing none. Is there anybody in the audience who would like to, who is not in favor of this application, who would like to speak to it? Okay, hearing none. Mr. Timmons, do you have any other statements that you would like to make, or any other questions that you would like to ask either the board or town council or the officials that are present?
Well, I'd just like to clarify what Mr. Rubel said. You're saying you don't agree that it was residential back in like the 60s or 70s. Am I correct about that?
Only because I remember when it was a pool hall.
Yeah.
In the bowling alley.
I never meant to imply anything other than the date that we have submitted, which was 93. But beyond that, do you also currently have a problem with it being residential? If the board were to grant the use relief, you're saying that you have an issue with that as well, or?
Do you have my occupancy? Does the board have my occupancy?
Yes.
Can you put that up on the screen?
You want me to do that?
I appreciate it, Bob, if you could.
Yeah, hold on a minute.
Oh, that's for his occupancy.
What's that?
Can you see that okay?
Yeah, it's an 1820 East Water Street, first floor, retail and commercial, second and third floor residential. 9th edition, the 4 residential units only on the second and third floor. That was my occupancy in June of 21. Now, if the board wants to give you your relief, that's up to the board, but that's the way I look at that unit.
All right. Well, I just wanted to clarify that when you were saying you don't agree, I thought you were against the application, but I acknowledge what you are saying. You and I have discussed this on a few occasions where I claim non-conforming, you said no. Well, as I told you, I accept your, not accept, I have to accept. So your interpretation stands. I recognize that in the eyes of the town, this occupancy permit is what the building is. And that's why we are before the board this evening looking for the relief. And my position is that that relief can be granted without substantial detriment, because I believe that once, if the use were approved, then we would be certain that you would be coming in and inspecting the property and feeling comfortable altering that occupancy certificate. So I just wanted to clarify that.
Yeah, that's fine.
Thank you. Thank you. And Mr. Chairman, thank you for this second opportunity. I'll rest, allow the board to deliberate. Thank you.
Okay,
Mr. Chairman?
yes,
Yeah, may I ask a question of Attorney Galvin, please?
yes, you may.
Yeah, Counselor, what standard would have to be met for this variance to be allowed?
It's the same standard that we have for a dimensional variance. There has to be something unique about the soil shape or topography of the lot that's, specifically affects this lot, not generally the zoning district. That there'd be a substantial hardship, financial or otherwise, to the applicant unless the relief was granted. There's supposed to be a nexus between the unique circumstances and the hardship. It's not supposed to be a personal hardship. And then I think Attorney Timmons has correctly stated the standard as it relates to, it can't be, there can't be substantial detriment to the public good or derogation from the spirit and intent and the purpose of the bylaw.
Thank you.
Could I ask a question? I think we heard after the applicant spoke that the building was essentially destroyed in a fire and then substantially rebuilt. So at the time the permits were applied to rebuild the property, were the plans and that permit application for commercial only on the first floor and for residences above, was the property rebuilt at the time to a building permit and an application that allowed for that, or was it actually applied for as residential only on the second and third floors in the rebuilding permit?
The owner that did the remodeling was told from the fire department and the building department that that first floor had to be commercial, not an apartment.
So was it rebuilt at that time? I'm not trying to get a sense of like the.
No, it was done over, but I mean, you can have an office with a kitchen in it and a bathroom.
Sure.
But then they ended up with bedrooms and, made an apartment out of it. I mean, you can have an office space with a kitchen and a bathroom.
Absolutely. So it's a use question, but there was a building permit to rebuild after the fire. Do I understand that? And that application was for residential units and one floor of commercial. Is that what I understand?
Yeah.
Correctly? So I'm struggling with the idea of the apartment being pre-existing if just as short as a couple of years ago, there was a building permit in the town and an occupancy permit that shows it's only for residential units.
Yes, and Mr. Haynes, I just want to add that at the time of those renovations and repairs after the fire, that if there were a fifth unit put into that building, it would have required a sprinkler system per the state law, being more than 4 units. Which we did, which was not done because it was, it was only permitted for 4 units.
Can I ask a question?
Yeah, yes.
Okay, I didn't want to interrupt. I want to ask Attorney Galvin just to clarify. I believe the question is whether about the revitalization overlay district. Does that say that the building has to be the first floor has to be commercial and then the upper floors can be residential?
Right.
I was just looking for a question if that's what for consistency.
Can you give me just 1 minute? I'll pull up the bylaw. I don't know that aspect of it off the top of my head.
I just wasn't sure if it was only street facing part of the business had to be commercial or if it had to be the first floor. So I was just curious if they had to have from front to back commercial by that.
I think it's the same. It was the 2013. It's the same as in the B1. It simply says, 2-family and multifamily residences except on or below street level floors as a use in that zone.
Okay. If that's the case, that's the answer I was looking for.
I think that I have the bylaw up in front of me.
Uh-huh.
And it lists the following uses are permitted as of right for projects within the, well, that's the Union Street corridor. That's not it. Or is that
I
what this?
think that's part of it.
Okay, I wasn't sure whether it fell within that, but
It's like an overlay
You
district.
want the site, Bob?
it looks like it's subsection E1A2, which allows multifamily dwellings. And also the conversion of existing buildings to multifamily dwellings is allowed. Mixed, I don't know if there's going to be a mixed use project or an element to this, or it's just going to be only residential.
There's a commercial use on street.
Yeah. That's what it's actually. So just mixed.
There's a minimum lot area, 500 square feet of lot area per dwelling unit.
Are you reading
The downtown Rockland,
paragraph C? No, 3C, the mixed-use development projects, where the area devoted to residential uses within a mixed-use development shall occupy at least 51% of the gross floor area. Residential uses shall not occupy the ground floor level of a mixed-use development project.
correct. Well, that's why I was trying to figure out whether in fact this was still in the future going to be a mixed use development project, because if it is, obviously that answers that question.
In the B1, it's, it's an overlay. So in the B1 district, it's also, it also prohibits first floor residential use.
Yeah, but the overlay district is more permissive.
Absolutely.
And if it's more permissive, it's perhaps multifamily is allowed by right. But you can't have a mixed use building with any first floor residential. That's 100% sure. Jim, had you looked at whether this project could be permitted as a residential project and allowed under the bylaw, thus obviating the need for zoning relief?
I have not. I worked off the overlay, that EB3. And that was it. 415-21-2, and then
Yeah.
paragraph EB3.
Well, if your client were to look at this project as solely a residential development, it's possible that he could have first floor living without the variance.
So you're saying convert the front commercial to a residential and make it 6 commercial units?
You might want to pause and think about whether that's a preferable project if that's what's renting, and it might obviate the need for the board to make a decision on a variance. I don't want to project what your client might want to do with the property, but I think it's up to you guys to decide. But it looks like multifamily dwellings are allowed there, so.
It's subject to paragraph G, there's dimensional and density requirements.
Correct.
There's probably some parking requirements. as
500
well.
square feet is not a lot. Then I think you'd be just dealing with, the parking requirements and the fire chief's requirements for sprinklers or fire requirements and inspection by the Board of Health.
Bob, are you looking at section E?
I'm looking at section E1A, residential
Okay.
projects.
Can you go down to E EC,
Yeah,
E1C sub-districts, because the E1 is relating to sub-districts.
I see C1, the Webster,
Yep.
Webster,
That-
I don't know which sub-district this falls into.
Well, I don't think it does. The sub-district, the following sub-district is the art studio. And,
Well, it's gonna be
Yeah.
located within one of these districts.
craft studio and workshops. So I think they're looking at the old factories.
Right, but what does this property fall into in terms of a sub-district? Because if it's in the Webster Artist Studio sub-district, multifamily residential uses are allowed. And if it's in the Sandpaper Artist Studio sub-district, they're also allowed.
Right.
And then in the Emerson Loft sub-district, multifamily residential uses are allowed. So it's like in all of those districts, sub-districts, those multifamily residential use allowed, but that doesn't mean, that means no mixed use.
Right.
And I agree with you, and I think there'd be a need for a variance if this is intended to remain a mixed-use project or a unit.
Right.
And then you wouldn't be able to have ground level residential use absent a variance. I'm just tossing it out there because there's a way of looking at this if there's not a desire to have more commercial space there to permit without zoning relief. That's why I mentioned it.
It's not so much a, if I may, Mr. Chairman, may I address the question?
Yeah, yes.
Okay, thank you. It's not so much a lack of desire, it's a lack of demand. When they bought the property, they were trying to get a commercial tenant and just unable because it's in the rear of the unit. You know, to the extent that there's always been a demand for residential use, and to the extent you've just cited these other districts and the fact that they still encourage or invite residential use, I just say that that kind of speaks to what we're talking about in this application, that there is a demand for residential use in that area. That right now, I agree with Mr. Rubel, or we accept, as we must, Mr. Rubel's interpretation that the use in the rear is not legal, and we're simply looking to legalize it. I'm sorry that I may have caused some, that I may have misled a bit about the non-conforming aspect. I was just explaining where I was coming from initially when we talked about, you know, the history of it, that I thought this residential use was in play already. But it's clear that in that area, there's a desire for residential use and a need. If this variance were to be granted, then we're all set. But if there are concerns on the part of the board, I'm happy to agree to continue it for, if the board would grant a continuance for one meeting or two. And let me speak a little further with Mr. Rubel and Mr. Galvin about what their thoughts are to clarify. But I feel that the presentation before you this evening is clear enough that, you know, there's no real strong opposition. There's one little question from a neighbor. Your fire chief has indicated that he wants us to address a fire suppression concern, which we'll do. And so that the, you know, if you were to grant the use variance, that would be consistent with the intent of your ordinance. You'd have the commercial use out front, residential uses in an area where there's demand. And I think that it would be an appropriate exercise of your authority. But in saying that, I would defer to the board as far as if you don't agree with me, then I'd ask that I have more time to talk to Mr. Rubel and Mr. Galvin.
Greg, if I may,
Yes.
is Chief Duffy still on?
Hey, Bob.
When they had that fire, was there an apartment in that space out back on the first floor?
At the time of the
You
fire,
remember?
it was.
It was? Okay. So it's been an illegal apartment for many years. Before the fire and now after the fire.
I don't know how long after the fire or how long the most recent, how long it's been occupied recently, so, but before the fire, or at the time of the fire, there was a, family living there.
Mr. Duffy, you say that there was a family living there in that unit back there?
I believe it was a couple with either one or two young children. I'd have to go back and look at the notes on the fire. I'm going off memory.
Okay, yeah, because it's just a one bedroom. The floor plan shows a one bedroom unit. And I was just wondering how a family could live in a one bedroom unit.
There were also, the front unit was also being rented as an illegal apartment at the time of the fire as well.
So there were two families there on the first floor.
Correct.
Okay, well, thank you.
Again, I just want to clarify, if we're, as a variance, we need to make a variance level of finding, a hardship level of finding that runs with the property.
Correct.
So I don't want to be the, look at this variance standards are always very rigorous standards. Someone would say that they've never ever been met. But the reality is the board has the authority to make the findings if you think that you can make it. And there have been some use variances granted in the past. They're not granted very often. They're granted sparingly, I would say, but usually when they have been granted, they've been granted because there was a desire to effectuate probably the most appropriate use of the land. And that's not a specific standard, but that's something that the board has gone to when it felt it needed to.
Are there any other questions from the board? Okay, the applicant has requested a continuance in order to possibly speak with Mr. Rubel or further with Mr. Galvin. How does the board feel about a continuance if Mr. Timmons wants to go that way? Mr. Baker Jr.
Mr. Chairman, I would have no objection to that whatsoever if Mr. Timmons and his clients feel it appropriate and perhaps even necessary to take a step back and perhaps come up with a different approach. Obviously, speaking for no one other than myself, I don't see how the requirements can be met based on the presentation that's been made to allow the variance. So if they can think of something else, I'd be more than happy to consider it at such time as it's presented. But again, I'd have no objection to a continuance.
Is there any other?
Mr. Chairman,
Yes.
I'd like to make a motion that we continue the public hearing for 1820 East Water Street until our February 7th meeting.
Okay,
At the request of the applicant.
Second.
Okay, there's a motion on the floor. It's been seconded. All in favor?
I'd like to have the applicant talk with the fire chief about what kind of system he's gonna have to put in there if we do grant him the variance? Because it might be way over budget on what he, to do that, to rent that building out, that floor out. Because he would have to sprinkle, if I'm not mistaken, I think the fire chief said he'd have to sprinkle the whole building, not just that unit. Anything over 4 units has to be sprinkled.
I want to know when the tail shop is.
So he may want to talk to the fire chief or whoever's in charge of the sprinkler systems in town to get a cost estimate on it.
Okay, all right, so there's a motion. There's
I'm
first.
just wondering if we should hear from Deb about that date.
Deb, is the
February-
7th,
February 7th is fine.
February 7th?
Yes, at 7:30 we could do.
Okay, all right, very good. So I'll put it to the board to vote to continue. Mr. Baker,
Yes,
Mr. Baker Jr.,
Yes.
Mr. Haynes,
Yes.
Ms. Gomez,
Yes.
and Mr. Galley.
Yes.
Okay, so that's a vote. All right.
what
So,
about yourself?
and yes, and myself is a yes as well. Thank you. So, Mr. Timmons, we'll see you on the 7th of February, and you can make whatever discussions you feel necessary or meetings with Mr. Galvin and Mr. Rubel, and come back to us with what you find.
Well, thank you. I appreciate very much the time and diligence the board has provided to us tonight, reviewing the application. Thank you. I'm sorry for number 2 on the agenda, but I appreciate what the members did for number 1 on the agenda. Thank you.
You're very welcome.
Night.
Good
Good
night.
night. Okay, so that being done, we'll move on to the next public hearing, and a remotely conducted continuance public hearing will be held by the Rockland Zoning Board of Appeals on Tuesday, January 3rd, 2023 at 7:45 p.m. on the application submitted by Felipe De Silva Pinheiro, 45 Greenwood Street, Rockland, Mass. 02370, for a Chapter 48, Section 6 finding and/or appeal from a decision of the zoning enforcement officer pursuant to zoning bylaws, Section 415-35, off-street parking requirements, Section 415-88, general provisions, Section 415-90, violations and penalties, and Section 415-92, procedure for appeals. The petitioner is seeking a finding that having his tow trucks on his property will not be substantially more detrimental to the neighborhood and/or appealing to the cease and desist order dated October 24th, 2022, relating to the premises known as and numbered 45 Greenwood Street, Rockland, Mass. The property is located in R1 Residence Zoning District, Section 415-8 of the bylaw, and is further identified as Lot 23, Map 28 on the Rockland Assessors Maps. The owner of the property is Felipe De Silva Pinheiro, 45 Greenwood Street, Rockland, Mass. 02370. So with that, yes, you're muted, Deb.
So Rob was a voting member on this in the original hearing.
Yeah, okay. And Mr. Galvin.
Yeah.
Yeah, Rob was a voting member.
Okay, but did you have 5 of the rest of you at the prior hearing?
I believe we did.
Okay, so that wouldn't affect, so you would have to exercise the discretion to appoint one of your alternate members as a voting member for the meeting, provided they can affirm that they attended the prior session.
Okay, so,
Do that session.
Mr. Galley, you were at the,
I attended. I just wanted to let you know in case you need it.
okay, all right.
So, probably Stephen and I don't know whether Nicole was on at that time or not, but so Steve would be the logical choice.
Okay, so that, Deb, could you read who the voting members were on this application?
Yes, it was Rob Rosa, Greg Tansey, Tim Haynes, Robert Baker Senior, and Robert Baker Junior.
Okay, so, all right, Mr. Galley, you're going to take Mr. Rose's place?
Right.
All right, so with that,
Mr. Chairman, we're only gonna be discussing the section 6 finding and the appeal.
that would be correct. And also the cease and desist
Right.
issue as well involved in this application. We all went to a site meeting, and we observed the site as a whole. A letter did come through through one of the abutters this afternoon, or at some time, and it claimed that a large amount of fill was deposited on the site. Mr. Haynes, do you have that letter?
I'm looking at it right now.
It's a hand written letter. The writing is relatively difficult to read, but it was
Hundreds of yards of material brought in by tractor loads to the rear of 45 Greenwood.
correct.
That one.
Yeah, I think it's 56 Hatherley Road.
It's Craig
That's what it looks
Erickson.
like. I can't remember. It's cut off at the top. Craig Erickson,
Erickson.
Erickson.
Erickson. It's cut off on my copy of it.
Yeah.
So
He owns that side, Greg, where we saw the tires pushed up against the stone wall.
Yeah, I gathered that.
Yeah.
So we've got a
Has
concern
anything
that-
changed since last time?
Well, Mr. Haynes, do you want me to read this letter into the record?
Oh, sure, absolutely. So I've lost it here. To whom it may concern regarding 45 Greenwood Street, Rockland, Mass. This communication is for specific regard to the hundreds of yards of material brought in by tractor loads to the rear of 45 Greenwood. I'm not sure where it came from or if it was contaminated. It's spread around the property. There's tires, dirt, and materials pushed on my property. It's very unfortunate that my stone wall was covered and buried under this material. To remedy this situation, I would want the said dirt, debris, tree, tires, and metal garbage removed from my property with a 15-foot buffer. I have concerns of 21E contamination and retaliation. I'm available for further communication. Best regards. And Craig Erickson, is that?
Yeah.
Somebody knew the neighbor. I believe that's his name.
Tim, I don't have that in front of me. Was it dated?
That came by email late in the day today. We got that at after 6 p.m. By email.
Right, no, I understand, but was there a date on the letter itself?
Oh, I see. Bear with me a second. Go back to it. It was only dated by the town clerk, stamping it in as received today, 1/3.
Thank you.
At 2:55.
Is the applicant here to speak,
Yeah,
or his lawyer, or?
Mr. Philippe, would you like to explain to the board what the issue is with all this fill material that was brought in and when it was brought in?
Was over the summer. I bought like probably was 6 or 7 triaxle, probably even more. Was clean room. I put grass behind my house. It was a motocross track behind here back on the days. I got everything straight up to make a backyard. Back on the days was just a track. And now I'm finally set up my backyard the way I want. So I did put grass all over the backyard, and it was a lot of loam that was splat off the backyard also.
Oh, when the board went out there, I didn't see an awful lot of loam and seeding. I saw what looked to be a lot of removal of material, at least.
No,
on
the material there was pushed to the side was for the track. It was a lot of jumps. So we got everything straight up. So move a lot of the materials to the side of the property. And from the fence going towards the house, it's where we put all the loom and we did the grass.
I'm sorry, when was the loan delivered again?
Was over the summer.
Over the summer, so, okay, months before we visited.
After that was no material bring to the property at all.
Thank you.
Are there any questions from the board to the applicant?
What's the status of all the unregistered vehicles?
That's been removed. The only thing is still there is that dump truck that I was moving the trash out. It's too muddy back there. I wasn't able to move it. And the plow truck is the only thing is still in the property.
What about the car under the top?
Oh, that car is still there. Yep. I wasn't able to move. It's too muddy back there right now. I hope I can move by Friday.
And what about the RV?
The RV is going to North Carolina in about 2 weeks.
So the RV is still there as well.
But yeah, it's still there. But also, I'll be getting registered the RV. I checked for insurance. It's going to be only $1,100 for the year. So I'm looking for an appointment to get registered the RV. Because it's going to come back home anyway. So I don't want to have this kind of issues anymore.
So the total number of unregistered vehicles on the property right now is how many?
3.
Plus the 2 tow trucks.
The tow trucks is registered. I send everything to you guys. Sticker, decal, sticker that also we have to have the truck to get registered.
Right. So you're saying that the 2 stickers that you sent, or the photos of the 2 stickers that you sent to us today, 1 sticker belongs to each of the 2 trucks?
Yes.
Okay. And can you tell me why those stickers don't have vehicle identification numbers on them?
Yes, they do. If you look at it, they do. Both will have. They have to have it.
I know. I couldn't see it.
Is there?
Do you have the paper registration?
Not on me, it's on the truck.
Well, if you register them, you got a paper registration with,
No,
Plates.
the only thing they give is a receipt like you pay the tax. When you go to the motor vehicle, you don't register those trucks, you just pay tax. You pay the tax, you title the truck in your name, and then you request for a decal sticker, where you just put on the truck and go get your sticker. You need to have the registration for your plate, is the one that I show you guys that day. There's no way you can get a sticker if you don't have the truck registered.
what plate is on the truck now? Is there a repair plate on there?
Repair plate, yep,
So the truck's not registered.
yes it is. It's registered under the company. That's why we have to have a decal sticker.
So you pay excise tax on that truck
Yes, I
through the
did.
town.
Yep.
Could I ask the assistance of my colleagues on the board to see if they can see vehicle identification numbers on either of those stickers?
I couldn't, Bob.
I couldn't either. It's my understanding that a repair plate is not a plate that's is used for, you know, everyday commercial use. A repair plate is for transporting a vehicle, you know, from a dealership to some mechanical garage to be repaired or something of that nature. But you know,
You use a
it's-
transportation plate. Repair plates is for repair shops and for towing companies.
But both
well,
chapter, both
it's my understanding that any vehicle that has two wheels on the ground, when it gets towed, has to have some plate on it. And if it's an unregistered vehicle, you would put a repair plate on that vehicle that's being towed with two wheels on the ground.
No, if you,
This is the nature of a repair plate as I understand it. A commercial use requires either, well, usually it requires a commercial plate. I mean, I've never seen any trucks operating as a business without commercial plates.
well, if you look all the big companies everywhere, they all use repair plates on the tow trucks. There's no big company that use commercial plates on trucks.
as I
on the
recall,
towing
sir,
business.
one of the things that was mentioned either the last meeting or at the site visit, you made a reference to what other companies do. And I believe one of the members asked you to present some evidence that other companies do exactly what you do. So do you have that tonight?
No, you guys asked me to prove it that I can use the repair plate on the truck. And I did call on the motor vehicle. I was on the phone for 2 hours to get a hold of them. And they told me the same thing. The only thing you mean, if you get pulled over by the police, they have your truck has to have a decal plate match with the VIN number for the truck, and that needs to have the sticker on it.
And again, my problem is that nobody can seem to see the VIN on either one of those stickers.
I'm just reading the RMV website, and it simply says a repair plate is issued to a repair shop to allow the repairer to drive unregistered vehicles on the road for testing.
That's for repair shop. How about for towing?
Unfortunately, the chairman asked the applicant to provide this kind of documentation or cite that rule during our site meeting to prepare for this meeting. So if we can't, it's not our responsibility to find it, as far as I understand.
Yeah, I did call them.
We'd like to find it, and if it's true, we'd be happy.
I mean, if I was able to use a repair plate of the truck, how am I gonna get a sticker from Massachusetts?
I'm just gonna say again, the chairman asked for something to show that it was authorized to be used on a tow truck in the manner that you described.
If it's not authorized, I'm not gonna be able to get a sticker on it.
My recollection might be faulty, Steve, but I thought that the request was that the applicant provide something from the registry to that effect.
Right.
Yeah, that's what I thought. I mean, I figured if he could find anything from the Massachusetts state government in that manner, that would cover that question.
And I did ask for them. They said it's no. I mean, it's nothing that you can just prove it. I mean, she even asked, "Do you go pulled over before?" I was like, "Yeah, a bunch of times for guilty." Do you have any problems before? Nope. How long you been running your business? 15 years. So why they asking about it? That's exactly what she said.
Well, we're spending a lot of time looking at other screens on our computers, trying to find something to support what you're trying to tell us.
Mr. Haynes, have you found any section regarding towing, or is the silent on towing?
There's again, I'm not an expert. I'm just reading a tow truck can display a commercial registration plate, but it cannot tow an unregistered vehicle if any of the towed vehicle's wheels are in contact with the road. So you can get a tow truck with a commercial plate. A repairer, somebody who's you put a repair plate on an unregistered vehicle, but a repairer who is operating a vehicle owned by the repairer, which is designed to draw, tow, or transport motor vehicles and displays a compliance decal, may tow or transport an unregistered motor vehicle pursuant to the MGL statute. If the towing vehicle is properly registered, displays the valid repair plate, maintains insurance, and it also provides coverage and so on. So you can get a repair plated tow vehicle if you are a repairer, if you're in the business of repairing cars. So,
But that repair plate goes on the vehicle being towed, not the tow truck vehicle.
no, it goes on the tow truck.
Goes
So,
on the tow truck.
Yeah, if you have a repair plate on the tow truck, you can tow a car behind with the wheels on it with no plates, no insurance, nothing. The repair plate will cover everything. If you have a commercial plate, you can only tow a vehicle with no insurance or no plates on the back. You cannot be touching the ground. That's the difference between commercial plate.
Tim, I believe the distinction you made was that in order for the tow truck to use it for that purpose, the tow truck has to be in the bid or used by a business that does repairing.
That is how it reads. A repairer who is operating a vehicle owned by the repairer designed to tow. So it is in the sense supposed to be for the way I'm reading it, it's supposed to be if for repairers, there's a separate section for dealers, and if you have a commercial plate, then you put a repair plate on the unregistered vehicle if you're towing an unregistered vehicle.
That's another way you can do also, but then you have to pay for more insurance.
So that's what I'm reading on the site. So having there are there are other requirements of it, but putting a isn't necessarily, does not necessarily mean it's unregistered. It's registered as a repair vehicle.
Does any other member of the board have any questions? Ms. Gomez, do you have any questions for the applicant?
No.
No, okay.
We
Mr.
want to hear from Attorney Galvin.
Yeah, I was about to say, Mr. Galvin, do you have any, Attorney Galvin, do you have any questions or comments?
It sounds like you're missing some information that you really need.
It was asked for at the last meeting, plus the site meeting.
I mean, this is an appeal.
Yes.
You know, the applicant, I mean, you know, I think everybody's been pretty clear that you're looking for certain information, you don't have it yet. You know, perhaps continuing this to the next meeting and making it explicitly clear to the appellant here what's outstanding, and if it's not there, then, you know, you may need to close the hearing and take, you know, a vote on what you should do here. I mean, you're free to deny an application on the basis of lack of information if you've given the person fair warning what you were looking for, and upholding the building inspector. That's one option, but I always try to be practical about it, and perhaps there was some misunderstanding. If there's any misunderstanding, I'm going to suggest that the board be clear and actually have Ms. Shuttlesworth contact this gentleman and tell him what information it is that you're looking for in writing and when you want it filed. And if it isn't, then the board may proceed to adjudicate the matter.
Again, not speaking for anyone other than myself, I thought that what we needed was made clear to the applicant at the last meeting and again at the site visit. Which is why I'm a little bit mystified why we don't have it tonight.
Well, I like to say I agree with the sentiment that we thought we were clear. I feel like we were clear about what we wanted tonight, how we want it basically documented. I just want to say I'm in favor of allowing him another chance to try to produce a document citing the Massachusetts Department, Registry website or something that explains what he's doing with the repair plate, that supports what he's doing. And if he's allowed to have a clarification sent by Deb later, then I think that would be appropriate. Give him one more chance and to clarify it. Maybe, I don't know if Deb needs to talk about it with Rob or Greg or someone who's better expressing this, or Tim, but I think I'm in favor of that. That's all I got to say now.
At this point, does it, if there's no other questions or discussions, or Mr. Rubel, do you have anything that you want to add? I haven't heard from you. I don't know if you have any comments or thoughts.
I was just wondering, I mean, he's trying to run a business there, his own business, okay? If I'm not mistaken, I think he is running his business there. So does he continue on running the business there? Are we allowing him to run the business in the residential area? I don't know.
Okay.
But I'm not running the business, I'm just parking the trucks. I mean, running a business, I run the business in Pembroke. It's where my business is located. I'm not running the business at my house at all.
Don't you have a tow truck that can't be there unless you have a permit from the zoning board?
The two trucks that I have here, both with under 7 feet. I mean, the one I'm applying for is the one is over 7 feet.
That's right. So the answer to my question is yes, you do. You have one there that's oversized.
No, the one I want to park here is the one is oversized.
What are you gonna do with the smaller one? You gonna
The
keep that
small one is
on?
gonna go to the tow yard.
What about the green one?
The
That
green
gonna
one is
stay
the
there?
small one. The green one is the one who's gonna go to the tow yard. The small one that was right on the corner.
And the flatbed that was there is gonna stay.
Yes. The flatbed is under 7 feet.
You do a 24-hour tow service. You answer the phone at your home,
Yes.
then you're running a business.
I answer my cell phone. It's
You
not my
still run
home.
a business.
I'm sorry?
You answer the phone for a business purpose, right?
My cell phone is run my business.
And you answer the phone at the house
I answer, yeah, my
for
cell
your
phone. Yep,
business, for your business.
for everything.
So I'm confused on one issue. I thought a tow truck, no matter what, a tow truck was not exempt under the size statute. A tow truck flat out is a commercial vehicle, and that there can only be one overnight with permission. So that's number 3. So commercial vehicles shall include and they list a lot: dump trucks, tractor trailer trucks, ramp trucks, flatbed trucks, tow trucks. It is a commercial vehicle. There's no size limitation. And so at this point on this property, you can't have more than one inoperative or unregistered vehicle. And on this property, you can have one, with our permission, tow truck that stays with you overnight. And I don't know how the other board members feel, but I would not entertain a permission to keep the overnight vehicle until the place is cleaned up and the other things are brought into compliance.
I want to make a comment. Take a second.
Yes.
I'm done.
Mr. Galli?
Just to make that
Mr.
comment.
Galli?
I'm sorry, Tim, are you done?
I'm done.
Okay, I didn't want to interrupt. I just want to rewind back for a quick second about Mr. Baker Senior's comment about operating a business out of the home. Just the idea that he's answering a cell phone to take calls for the towing. Generally, I don't know if that, definitely calls it as operating a business in the spirit of, if he was a tow truck driver at home working for him, the employee wouldn't be considered running a business. And if we're a remote worker working from home, we don't consider our homes and our apartments as running a business while we're just working remotely. I would almost think him answering a phone call, just the phone call, would not be considered the commercial activity that we're concerned about. Towing and bringing a towed vehicle into his yard would be operating a commercial business, beyond just having a tow truck there. But I would like to say, I would not, unless the law says so, absolutely, I would not want to say that answering an on-call, request for service on his phone at home, I would not want to count that as operating the business or operating a commercial enterprise. I would just like I said, I'd rather just be about the tow truck operations, what they have on the property for vehicles, unregistered vehicles, and whether they're actually towing vehicles. He did say at one point that he might stop at home with the towed vehicle, not to store it, but to have it there for a short time, maybe just to stop off and say hello to the family. But he did mention that he would bring it home, not to keep it there long term, but it did seem like it would be there for a short time, maybe just a few hours. That I would be questioning how much that counts as commercial activity against him. I would think that might count against him, operating commercial enterprise and residential property. That's all I want to say.
Mr. Tanzi?
Yes.
Weigh in on this whole issue.
Yes.
Home occupations are not new, and it's something that our bylaws encourage. Okay. But it's supposed to be done from the confines of the home, limited to like one work truck and not like a huge work truck, like a typical truck that someone that's employed as a contractor might bring home in the evening. The storage yards are supposed to be somewhere else. And for all intents and purposes, the business can't really appear to exist in a residential neighborhood. So that's kind of how it works.
Yeah, I agree. Is there any other questions from the board or anybody else?
I have a question.
Okay, Mr. Galley?
Are we concerned about the fill that was brought into the property? Do we need any kind of documentation on it? I don't know if that's our responsibility or if another department like the Board of Health has to see that. Just a question.
Well, I've seen it. I think the building inspector has seen it. If there's fill and tires and debris on the property or on a neighbor's property, you know, that debris has to be removed. That's not a residential use. I don't know what the tires were there for, whether it was a part of
It was part of the
towing
motocross
business
track.
that he's in or whatever, or recreation for, you know, riding motorcycles or whatever.
That's what it was.
All right, but still, I mean, you know, a recreational use of, you know, dirt biking. I mean, our bylaw, our zonings, we've got use regulations, and one of the criteria is noxious usage, and it covers dust, it covers sound, it covers aesthetic issues. There's a variety of things there that, you know, the operation of, you know, a residential area for riding dirt bikes around with tires as a track, it really is not in harmony with a residential property. And again, as Mr. Galvin has stated, home occupations are occupations that are confined within the house. They're not, it's not something that the neighbors would see happening. I mean, you are running a 24/7 business. You can, you know, get called at 3 o'clock in the afternoon or 3 o'clock in the morning. So I mean, that's not, you know, that certainly does not qualify for a home occupation.
Yeah, I
Yes.
never leave it like at this time. I don't need to work at, you know, me at 2 o'clock, 3 o'clock in the morning. But if I do get a call at 10 o'clock and 9 o'clock and I'm at home, yes, I do need the truck around. But no, I don't need to work 2 in the morning, 3 in the morning.
Anyway, well, I guess if there's no other, but is there anybody in the audience who would want to speak in favor of this petition? Is there anybody in the audience who would want to speak against this petition? Yes, this is Duchesne.
I'm sorry, Del Shawn.
I'm sorry.
That's okay. Health agent for the town of Rockland. My concern is the disposal from that letter states as tires and whatnot. We don't know what's in there. I don't know if anybody utilizes near maps. It's a great feature. You can go on there and actually see the property, what it was in 2019. You can see the property, what it's like. I think the latest capture is in October of 22, the most recent. You can see how it's cleared out. And you can also see the abutting property from the letter from 56 Hatherley. And I'm sure at some point we'll get another view. I think they snap them every 3 months. So you can see how the property has progressed. There were numerous tires. I don't know how many with the last time I was there. Those two you can also see on the aerial view of near maps. Today, we got this letter. So that's what I'm concerned about. All those tires, where are they? I've got some conflicting information today that Mr. Panero gave me, and then I was shocked to see this. So I don't know if the tires were disposed of properly. I don't know if a site visit that maybe I should go with somebody and see exactly what is this debris that this abutter is talking about. We don't know what's in there. It could be anything. So I don't know. I'm concerned about the disposal and the trash and the debris.
Yeah,
And I'm also concerned because I get calls all the time from the abutters, from the noise at night, the trucks coming and going, so it's a burden to my office as well. It's a nuisance.
yes, Ms. O'Shane, you could, if you wanted to visit the site, maybe Mr. Rubel would be kind enough to show you what he has observed. If that helps,
Yeah. If we can get permission from the abutter, the complainant, and we can get permission from Mr. Panero to go onto his property.
Yes, you can.
well, at this point, I guess I can put it out to the board. What's the pleasure of the board? Is there a motion to continue or a motion to close?
Mr. Chairman, I got a question for the applicant.
Sure.
Are you going to be able to get from the registry something that shows with the legible writing on it, the plate numbers and stuff, the VIN numbers for those tags that you sent us?
Yeah, I can get better pictures. I also can talk to Cape Way Towing. They're a good friend of mine. They are a huge company. They use repair plates in every truck. I can go talk to the owner there, and I'm pretty sure he's gonna send him to the right directions to get this proof.
That's a towing company out of Rockland, so it doesn't matter. We want to know if you can prove
Yep, I'll be
those
able to
plate
do it.
numbers and the VIN numbers for those stickers that you gave us,
Yep,
that we can see it legible.
yep, I'll
And
do that.
anything else that we ask, if we continue this, for you to prove. I noticed that one of the boats was gone.
One of the boats is gone. It's not gone. One of the boats is on the shop, getting ready for the winter, but it looks like it's gonna stay there for, it has some work that needs to be done. And the other one, I'm still waiting for the insurance to come to get it.
So just to be clear, so I understand, and I may have misunderstood you, sir. Every vehicle or craft that we saw on the site visit is still on site.
Back on the backyard, yes.
Okay.
What was that bill you gave us for 25 tires disposed of?
Was the tires that was on that truck, on the dump truck, and was some tires also when the fire department came, he looked at it, asked him to get rid of it. So all those tires are bringing to Brockton Auto, in Brockton.
Okay.
And some of the trash tires I just put inside that are the junk cars that I was getting rid of it and just put everything inside and dump.
So you brought junk cars on the property and filled them up with junk?
Nope, I got the tires on the tow truck and bring it out. I didn't bring no junk cars on the property.
Okay, you had said earlier that the truck you were loading when we were there was stuck in the mud and you couldn't get it out. So how'd you deliver 25 tires to Brockton Auto?
No, that 25 tires didn't came from that truck. 25 tires been the period that I've been dumping from the day the fire department came here until last week.
Why is the invoice dated for today?
because I went there today to get it because they never give me any receipt because I never needed receipt. I mean, I've been doing business with them for 15 years. And then the city hall asked me to have some proof that I dumped the tires on this place. So I went there, spoke with the owner, asked for the receipt, and he gave me no problem.
Can I ask Tom a question about the, I don't know what that's, the violation? And that's, so as I understand this, Tom, you've issued the violation, a cease and desist, but you're not currently imposing any fines on this homeowner. And so I'm curious at what point the fines will start, because they're pretty large in this town.
Well, when I issue a fine or issue him a warning or a fine, he cleans that area up. And then a month or so, he'll bring something back. It comes and goes. I don't know if you can remember, Phil, but the first fine that I sent you, you paid a $300 fine.
Yep.
That was a few years ago. So it comes and goes. It just needs to be stopped. That's all.
Yeah, but let's be very clear, Tom. Every time we get a complaint that, oh, Philip has 20 cars there, Philip, you was coming here right on the next day. And
Yeah.
every time you came was nothing what the neighbor was complaining about it.
Right. You've got issues with neighbors that you need to get yourself a legal counsel to put that to
Yep.
sleep. You can't
I've been looking
can't
to
get
that
the town
already.
involved with that. You need legal counsel to control your neighbors.
That's what I've been looking at.
So from my perspective on the board, again, speaking for myself, it seems that a continuance for both compliance on site and providing the materials to show that all vehicles that are on site are properly registered. We should give this a,
And the
period of
unregistered
time.
ones, the unregistered ones will be removed from the property.
For Friday.
where the fines begin. But beyond that, I don't see how we can consider, even like take under consideration an application to have a commercial vehicle overnight, until the issue of the cease and desist or fines and the situation is brought under control.
Mr. Chairman,
Yes,
at this time, I'd like to close the public hearing for 45 Greenwood Street and make a motion to uphold the cease and desist order by the building inspector.
if you make a motion to close, we'll get a second and then we'll deliberate on it. Is there a motion, a second motion to close the public hearing?
So I'll second that.
Does that mean that there wouldn't be a continuance?
That's right.
That's correct.
We've dealt with this enough. We've given them plenty of time.
So there's a motion to close. There's a second. All in favor? Mr.
Roll
Roberts,
call.
roll to call.
Yes.
Okay, yes, Mr. Haynes,
Yes.
Mr. Baker Jr.
Yes.
and Mr. Galley,
No.
and I'm a yes. So the motion carried 4-1 to close the public hearing.
Mr. Chairman, at this time, I'd like to make a motion to uphold the cease and desist order for 45 Greenwood Street issued by the Rockland zoning enforcement officer. I don't know what date it was.
All right, well, there's a motion. Does the board wish to deliberate before
We have to have a motion in a second, then we deliberate before we vote.
All right. Okay, so there's a motion being made. Is there a second?
I think we should have some discussion about it.
Okay, all right, so,
I'm not
You-
seconding.
Just on a parliamentary issue, Mr. Chairman, you can't discuss until a seconded motion is on the table.
all right.
If
All right,
nobody seconds it, is anybody seconding?
okay, so there's a motion, there's a second.
Now we can deliberate before we vote.
All in favor of a deliberation?
Well, no, we do, as long as there's a motion and a second, then you can deliberate and then you can vote if you so.
Okay, all right. So, Mr. Haynes, do you have any comments? Any,
I think I think we should let Tom continue getting the site cleaned up, and I think it's up to Tom whether and when he wants to impose the fine or allow a little more time. But I think it seems like the applicant is moving towards cleaning things up. So as far as I'm concerned, that matter is done. So it's really just for me, it's just a question of the permission to keep a vehicle on site, which I would not entertain until things are settled.
This property has been an ongoing issue for many years. When he had the dirt bike track there, he was creating dust, noise, pollution. The people in the neighborhood went to the Board of Selectmen and he stopped doing it. Then he started doing his towing business and bringing cars in there and all kinds of stuff. He cleans up a little bit each time someone goes there. But I think if we say we're gonna uphold this cease and desist, clean the property up, call us when it's cleaned, and we'll come back and look at it. This is gonna give him an incentive. Get off his butt and clean the place up the way we want it cleaned up. The town wants it cleaned up.
Those 3 vehicles back there, I can get everything.
Sir,
Right.
sir, we're in deliberation. You cannot, the public hearing has been closed. There is no public comment at this point.
Okay.
Mr. Baker Jr., do you have any thoughts or statements?
I think in the fairly brief time that this most recent matter has been before us, we've made clear to the applicant what we needed from him. We made clear to the applicant, certainly at the site visit, what the expectations were regarding removing some of the debris and certainly the unregistered vehicles, and it hasn't happened. So with that in mind, I would certainly vote yes on the motion.
Okay, and Ms. Gomez, do you have any comments?
No comments at this time.
Okay, Mr. Galley, would you like to speak to this matter?
Yeah, I think I'm in agreement with what I caught everyone saying, that it seemed to me that as far as unregistered vehicles on the property, I think we might have one less than what we saw, which was far too many, if I followed the conversation. Because I think he said one was off the property being repaired. That might have just been the boat. He does need to clean it up further, because now we found out that that loam fill was months before we were there, which means the property did not look clean enough, as far as I understand anybody wanted to do. A lot of the junk, tires, debris. So that looked like a matter that still needs to be addressed. And the idea that he's operating a commercial business in a residential, it's not zoned for commercial, so hard to let him do that. And we haven't gotten him to produce the documentation to support that those vehicles, the tow trucks, were plated properly. I would like that misunderstanding to have been given one more chance to clarify and come back, but all these other issues, I think we've seen have not really been addressed or are still bad, the property condition. So I don't really have anything more to add other than to just repeat what everyone else has just said, that the conditions that work against them are still there.
Okay, all right, and I would like to say that I do agree with the comments that the board has made. Before the board even made comments like incentives for coming into compliance. I mean, I think that's very huge. We were all out at the site. We saw 2 tow trucks. We know the nature of the towing industry. It can happen any time. It usually happens, accidents happen at night. You saw the driveway into that property. A truck has to pull out of that property and go a fair, 100 feet anyway, 150 feet down a driveway just to make it turn onto the street. So there's a lot of vehicle time just accessing that site or leaving that site. That even in broad daylight, it can be a nuisance situation. There's noise. There's the turning and bringing. Apparently, vehicles were brought to the site for convenience, most likely. I mean, you take a vehicle, you tow it, you drop it off at your house, you go to bed, you wake up in the morning and then take it to Pembroke or wherever. This towing business, a 24/7 business requiring, heavy equipment. It's just not, a residential area is just not, it's not conducive to it. It's not in harmony with our bylaws. There are other violations there. We've mentioned the unregistered vehicles. We've mentioned the tires and the fill. What was not mentioned was the junked bulldozer. I mean, that's something that no resident should be looking at stuff like that. And I think we've heard testimony that, it came and it go, that there's complaints, and then it kind of clean up his act for a little bit, and then the complaints would start up. We saw unregistered vehicles out there. We saw unsightly stuff like a bulldozer that's just rusting away, a parts dozer. We've seen other commercial vehicles, unregistered vehicles. We've seen fill. We've seen tires. I think it's time, we make him clean this up. And if he has rights to operate a certain vehicle off that present premises for a certain use, once he's cleaned up the site completely, everything that shouldn't be there, everything that's not residential, when that has been cleaned up, if he has the rights to apply for a special permit, then let him do so. And that's my thoughts on the matter.
In our packet, there's a letter on 45 Greenwood Street,
Yes.
starting back in February of 2012, stating that he would remove all vehicles from the property. The 514 letter cease to desist any work being done at the residence. The 12, 312 and 512, multiple complaint letters for noise, tires being dumped, unregistered cars, etc. It's the same thing all the way up to 10/24/22. So I mean, he's had 10 years or more to clean the property up. And like I said, he does bits and pieces and that's it.
Mr. Rubel.
Yeah, Greg, can we ask the applicant how much time he needs, whether it be 14 days or whatever? And also have Delhi set up an appointment with him so that I can go with Delhi on the site to see exactly what's been done. And have, you know.
Yeah,
how
I mean, yeah.
How much time we're gonna give him?
What you feel is a reasonable amount of time would be fine with me. I mean, there's a lot of heavy stuff out there that has to go. I mean, I don't know how long it'll take him to get rid of that dozer. He's probably going to have to find a home for the vehicles and for the RV that's parked there and whatnot. But you know, a reasonable time frame that you feel.
We can ask how much time he needs.
Okay. Philippe, how much time do you need to bring that site into compliance, to get those unregistered vehicles, all that, and the bulldozer out of there? And
You're muted.
You're muted, Philippe.
The bulldozer, I try to get rid of it. I can't get nobody here until the summertime because I'm gonna have to pay someone to cut that off and get rid of it. And I did find one guy, but he said he only do that on the summertime because he's gonna have to spend some good time outside. Because no machine will be able to get that out of there. So that bulldozer won't be able to get rid of until the summertime. The rest of the vehicles, no more than a week.
Now, we got a motion and a second on the floor. To uphold the building inspector cease and desist. We can put a, is Bob still around?
No.
No? Could we put a date that he can't do any, he can't have the tow truck there, but he can clean the place up by a specific date and then come back to us after the building inspector, board of health, and the fire department inspect the property and get a clean bill of health?
Well, why can't we wait?
January 17th would give
Well,
him
I was thinking March 7th.
Oh. I'm saying for me and Tom and Chief Duffy to go out and inspect next week. Tom,
Yeah, that's fine.
or this week?
Check with Philip.
Said he needs a week. And for
Well,
everything.
he doesn't need a week for us to view it,
Hmm.
right?
No,
So
no, you're gonna go out and view it and tell him what he has to clean up on there
okay,
to get off the
That-
property.
That doesn't need to be part of our motion.
right.
Yeah, I mean, enforcement is up to Tom. I mean, all we're doing is saying whether we're upholding it or negating it, right? So,
Yeah.
So beyond that, enforcement is up to Tom, and whether Tom starts imposing fines until it's cleaned, that's up to Tom. But I
And what do we do with the business right now?
We wouldn't be able to be there if we uphold your decision.
when we're done with the cease and desist, I think we're going to take up a motion about, and the only motion we have, I believe, is an application to store or to keep the tow truck on site. And at least from my
But
perspective.
That's
we're
part
going
of the
to-
business.
but I think
What I would propose is that, the business has to cease and desist. It's a towing business. There are trucks there in that business that shouldn't be used and clean up the site. And Tom, you can give him a date to do certain cleanups that's reasonable, and maybe a second date to get that bulldozer out of there, or that front end loader, whatever that parts excavator is out of there. If he legitimately needs 6 months to do that, that's one thing. But when he gets all that out of there, if he wants to petition the board for a lawful use of that property to run a particular business with a particular conforming vehicle, he can't do so until he's got that site completely cleaned up. And that will give him the incentive to clean it and to keep it clean.
So the tow trucks are gotta go?
Tow trucks have to go. Tow
Yeah,
trucks are not permitted.
Yeah, it's not a home occupation business. We've found that that's not in harmony with the residential zone. It's just the nature of these trucks, and even at that, these trucks don't even have backup warnings, which that's a safety element as well, but it's also a nuisance. So it's kind of a double-edged sword that this whole business that he's run out of the residential area is problematic. It's been problematic to the residents, and it needs to be cleaned up. The site needs to be cleaned up, and the inappropriate operation of a business in a residential area must stop.
So we just got to vote on the motion.
Right. So, so the motion was made, motion was seconded. Mr. Galley?
So we're voting to maintain the cease and desist?
Of the operation, yeah.
Right.
Okay,
And to clean the site up within a time frame that Mr. Rubel seems appropriate. And if he fails to, or if he ignores that, then the appropriate measures will be taken at that point, whether it be fines or courts or whatever. Hopefully it won't go that place. But once he gets that site, the sooner he gets that site cleaned up, the sooner he can petition the board in the future for a legal business.
okay, thank you.
Now, that doesn't mean that the board will guarantee it. If it's appropriate business, he'll probably get it. If it's more of the same, he probably won't. But that's a whole nother case down the road that's not part of this agenda. So, Mr. Galley, did you understand the motion that you're voting
Yes.
on? Okay.
Yes, thank you. Thank you. I just want to make sure that's how I understood it. So my vote is yes.
Okay. Mr. Baker,
Yes.
Mr. Baker Jr.,
Yes.
Mr. Haynes,
Yes.
and I'm a yes. So, okay, so that's a vote.
So I think, if you agree, I think we should take a vote on the other part of his application, which was seeking a special permit, for the commercial vehicle. He was looking for a Section 6 finding and a finding that he could have the vehicles. So within our
Yeah.
yes vote, do you feel like we should make a motion about that part of the application?
Yeah, I think that would be wise, just to be thorough. So, is there?
I'll make a motion to deny the application for Section 6 finding to keep the commercial vehicle on the property.
Okay, there's a motion on the floor. Do I have a second?
Second.
Okay, the second has been made. Any discussion? Hearing none. Mr. Baker, I'll take a vote for it.
Yes.
That's a
Yes.
yes. Mr. Haynes,
Yes.
Mr. Galley,
Yes.
Mr. Baker Jr.,
Yes.
and I'm a yes as well. So, so with that, a decision will be mailed out to the applicant. There'll be a date stamp on that date, on that decision. There's a 21-day appeal period. If you want to appeal it, you can do so. And I think that's everything. I don't think there's anything more to discuss.
Okay, do we need to do anything further to facilitate a meeting between town officials and the applicant?
That's up to the town officials.
Yeah, I think Mr. Rubel will handle that element.
All right.
And
do we have any other business to discuss?
Chairman, is it okay if I leave?
Sure.
All right,
Yeah.
thank you. Good night, everybody. Have a good night.
Good
Bye,
night.
Gally.
Thank
Have a
you.
good night.
Good
Bye-bye.
night. Yeah, thank you very much.
You're welcome. I'll be in touch. Me and Tom will talk.
Okay, very good.
Yeah, is our January 17th meeting at 6:30?
Yes, it is. Yes,
It is?
for 99 Church Street. Yes.
It meets at 6:30?
6:30. Yes.
Oh, that's the fire station?
Yes.
Okay,
January 17th. Yes.
January 17th, okay.
Motion to adjourn.
Yeah, I don't think we, do we have any other previous meetings that need to be approved?
No, I don't have anything.
Okay, all right, so I'll take a roll call to adjourn. Mr. Baker,
Yes.
Mr. Haynes,
Yes.
Mr. Galley,
Yes.
Mr. Baker Jr.,
Yes.
Ms. Gomez,
Yes.
and I'm a yes as well. Well, thank you very much, board. Thank you for tolerating me.
Thank you,
It's
Greg.
kind of a late
Greg?
one,
Yes.
but,
Good job, Greg.
you know, I
Good
hope
job.
Rob's doing well. And I guess we'll see everyone on the 17th at 6:30.
6:30. Okay.
Sounds
Very
good.
good.
Thanks again. Have a good night and happy
All
new
right.
year.
Good night, everyone.
Good
Good
night.
night, everyone.
Happy New Year.
Thank-
Bye.
Bye.
Where am I?
Hit the red end and then I'm going to end it. Want me to end it? I think once I click end, it will end you.
Didn't end me.
All right. I'll see you. I'll talk to you soon.
Yeah.
All right. Thank you. Good night.
Good night.